Unit 2, Part 4. Let's carry on. We're still with the FACE Act. So the Minister of Health approved an increase on the maximum amount payable to brokers with effect from 1 January 2024 in terms of Section 65 of the Medical Schemes Act, the MSA 131 of 1998. The revised amount is now 116 Rand 74, as I highlighted it for you here in red, so you can highlight it in your books as well, plus. So is that the amount plus value added tax? And value added tax is basically short for that is VAT. And how much is VAT? Do you know? It's 15%. You're a bit too slow. Or am I too fast for you? So you take the 116 Rand 74 cents, you plus 15%, this 15% VAT, then you get an amount of 17 Rand and 51 cents, and then you add equals it, and the total amount then is 134 Rand and 25 cents. That is the maximum amount the broker is allowed to receive commission. The effective date of implementation in respect of contributions received by medical schemes is 1 January 2004 and beyond, as per Government Gazette 50041, notice number 2288, dated 26 January 2024. Regulation 28, subsection 2, published in terms of the Medical Schemes Act, now effectively reads as follows. Subject to sub-regulation 3, the maximum amount, and you must underline this and remember this, the maximum amount payable to a broker by a medical scheme in respect of the introduction of a member to a medical scheme by that broker and the provision of ongoing service or advice to that member shall not exceed. Now you must listen carefully and look carefully. It shall not exceed either A, so it cannot exceed 160 Rand 74 plus value added tax VAT per month, or it cannot exceed 3% plus value added tax per month of the contributions payable in respect of that member, whichever is the lesser. And there is the key word. You must look at A, this 16 Rand 74 or 3%, whichever is the lesser amount. That is the amount you can receive commission. So let's look at scenario number 1. If you do calculations, we said John pays 2,500 Rand per month for his medical scheme. Can the broker get 3% commission on this amount? We said yes, because 3%, yes there, 3% on 2,500 Rand is only 75 Rand. So the broker can only get the maximum of 75 Rand plus VAT in this case. And in this case, the broker are not allowed to take the maximum amount of 116.74 plus VAT. As the sub-regulation 3 stated that they're only allowed whichever is lesser. You see, here it says you must choose between A and B, whichever is the lesser of the two. And in this case, the 3% is lesser than that amount. Therefore, they're only allowed to get 75 Rand plus VAT. All right. Let's look at another scenario number 2. Gary pays 6,000 per month for his whole family's medical scheme. That is him, his wife, and the 10 children. Can the broker get 3% commission? And here the answer is no. because 3% commission on 6,000 Rand is 180 Rand a month. And what did you say? You must look at the maximum of A and B, and in this case, the 3% is 180 Rand, and you must look whichever is lesser, and in this case, the lesser amount is 116 Rand 74. So the broker can only get the maximum amount of 116 Rand 74 plus VAT in this case. In this case, the broker are not allowed to take the maximum amount of 180 Rand, which is that 3% there, that 3%. As the sub-regulation 3 stated, you're only allowed whichever is the lesser amount. All right? And the lesser amount in this case, between A and B, is 116 and 74. So what you need to do is whenever you write somebody healthcare or medical scheme, you look at which amount is the lesser amount between the two, the 3% or the 116 plus VAT, 74 plus VAT, or the 3% plus VAT, and then you work on that amount. So I gave you two different scenarios so that you see how you can work it out. All right. I hope you understand this. Section 65 prevents brokers who are not accredited by the CMS for signing up members, and this section states that number one, no person may act or offer to act as a broker unless, and I highlight that unless, the council has granted accreditation. You can only be a medical scheme broker if you've got accreditation to such a person on payment of such fees as may be prescribed. 2. The minister may prescribe the amount of the compensation which the category of brokers to whom the conditions upon which and any other circumstances under which a medical scheme may compensate any broker. Number 3, no broker shall be compensated for providing broker services. So no broker shall be compensated for broker services unless the council has granted accreditation to such broker in terms of subsection 1. Number 4, an application for accreditation shall be made to the council in the manner and be accompanied by such information as may be prescribed, and any other information as the council may require. 5, a medical scheme may not directly or indirectly compensate the broker other than in terms of this section. 6, a broker may not be directly or indirectly compensated for providing broker services by any person other than a medical scheme, or B, a member or prospective member, or the employer of such member or prospective member, in respect of whom such broker services are provided, or C, a broker employing such a broker. Regulation 28 details how medical schemes may compensate brokers. Brokers can only be compensated if they have a written agreement with the relevant scheme. In a circular issued in September 2013, Circular 37, the CMS notified that it had published a document outlining the accreditation process for brokers and broker organizations. It says brokers must have a broker agreement with the medical scheme concerned before the broker can sign up members, and there must be a written service level agreement between the broker and the scheme. 2, a broker or advisor can only earn, as we said before, up to 3% of a medical scheme's members' contribution up to a maximum amount from 1 January 2024 of 116 Rand 74 plus VAT per month for introducing a member and providing ongoing service or advice to that member. 3. A scheme may not offer different amounts of compensation to a broker based on anticipated claims experience, age, health status, or employment status of the members being introduced. A scheme may, however, subject to certain conditions, apply a sliding scale based on the size of a group being introduced. So you cannot, the scheme cannot tell a broker, for all the young healthy people, we'll give you X amount commission. For all the older people that's sick, unhealthy, we're going to give you less commission. They cannot do it. It must be the same right through, except when you bring a big group. Let's say, for instance, you go to Toyota's factory or Nissan's factory, and you wrote all 6,000 people in the factory workers. Then they can say, all right, because you bring 6,000 people at once to us, we go on a sliding scale, we work out your commission, and you might earn whatever they decide. All right, but they'll work it on a sliding scale. Because between that 6,000, there will be, it will be various. So, And remember, they can only work on your income. So that 6,000 people will have different incomes because you'll have from your cleaner right to the manager of the plant. So on incomes of the base, and then I can also do on dependents. Each worker there will also have dependents. One will have one dependent, one will have no dependent, one will have 1, 2, 3, or 4. And I can only work on that. All right, so then number 4, brokers must be paid monthly when the medical scheme receives the contribution paid by the members that the broker signed up or to whom they are providing a service. 5, a scheme may pay a broker on an ongoing basis provided the broker continues to meet the agreed service level and the broker does not receive any other direct or indirect compensation for broker services. 6, if a member or employer notifies a scheme that it no longer requires the service of a broker, a scheme must immediately discontinue payment to the broker, as we said before. 7, a medical scheme may not compensate more than one broker at any time for services provided to a particular member. So they cannot pay 2 brokers for bringing them one member. No. 8, medical schemes cannot prevent a person from applying for membership of a scheme if they do not use the services of a broker. So if I walk into Momentum Health offices and I come to reception and I tell them I want medical aid, they cannot tell me, no, sir, you must work through a broker. No, it's not allowed. And then brokers who want to be accredited to sign up medical scheme members must apply in writing to the CMS, and then they must supply the following. A, documentary proof of a recognized educational qualification and the experience, appropriate experience. So they must show that they've got qualification, and we said, what qualification? Can you still remember that qualification? We said grade 12, that is correct. Or standard 10. Or matric. And if you don't have one of them, NQF4 qualification. Because that is all the same thing. It's like potato, potato, tomato, tomato. What's the difference? Lawyer and attorney, what's the difference? You see, it's the same thing. Documentary evidence of having passed or current enrollment in a relevant course of study recognized by the council. So basically, to show them that you are busy training, you receive training to be accredited. In the case of a juristic person, documentary proof and a sworn affidavit that any person employed by the person. For you who don't know what is a juristic person is like ABC brokers. Is ABC brokers a man or a female? A male or a female? You don't know. That is a juristic person. It's basically a business, a CC, a company, a Pty limited, etc. That is a juristic person. That's not a natural person. So document proof and sworn affidavit that any person who's employed by the person, so any person who's employed by ABC brokers or acting under the auspices of the person and under the rights or jurisdiction of agreement, who provides or who will provide advice on medical schemes to clients, is accredited with the council as a broker or an apprentice broker. Such additional information as the council may deem necessary. Any other additional information the council may require. So you recognize educational qualification. We already talked about it. It's a grade 12, matric, standard 10, NQF4. You must have minimum experience of 2 years as a broker or as an apprentice broker in the healthcare business. Provision is made for accreditation as an apprentice broker. Natural persons like you and me applying for accreditation as brokers are also required to satisfy the council that they comply with A, any requirements for fit and proper brokers, which may be determined by the council by notice in the Gazette, and B, any relevant requirements for fit and proper financial services providers or categories of providers, which may be determined by the registrar of financial service providers in terms of Section 8, Subsection 1 of the FACE Act. In considering an application for accreditation, the council can take into account any other information it has regarding an applicant, but the applicant must be given an opportunity to respond to this information. Accreditation is granted for 24 months, as we said before, and the council may at any time, very important, the council may at any time add or withdraw or amend any condition or any restriction in respect of the accreditation after they've given the broker an opportunity to respond to the amendment or the conditions. All right. So even if the broker responded and so on, after that, they can still add or withdraw or amend conditions and restrictions or restrictions. We said this before, a person cannot be accredited as a broker or an apprentice broker if he or she is unrehabilitated, insolvent, broke, disqualified under any law from carrying on his or her profession, or has at any time been convicted, whether in the Republic of South Africa or elsewhere, doesn't matter, of theft, fraud, forgery, or uttering a forged document, perjury, an offence under the Corruption Act, Act 94 of 92, or any other offence involving dishonesty, and has been sentenced, therefore, to imprisonment without, you see, without the option of a fine. Remember, we said it earlier on. Okay, so this falls now, the other ones fell under the broker, and this falls now under qualification and fit and appropriate experience. And so, yeah. So, yeah, it's if you're convicted of theft or fraud or forgery or uttering a forged document or perjury, an offence under the Corruption Act, which involves dishonesty, then you cannot say you're an honest person if you've got integrity and good standing and you've been sentenced. Been sentenced to imprisonment. No option of a fine. 10. The council may suspend or withdraw a broker's accreditation if it is satisfied that the broker no longer meets the relevant requirements, did not make a full disclosure when they applied for accreditation, has since being accredited failed to comply with the Act, has since they've been accredited failed to comply with any other relevant code of conduct for FSPs, published in terms of the FACE Act. So you have to follow all the acts. You have to follow the code of conduct. Or if the person has since accredited, so after being accredited, conducted his or her business in a manner that is seriously prejudicial to clients or to the public or public interest, or the person has been disqualified from being accredited. Before suspending or withdrawing a broker's accreditation, the council must inform the broker of its intention. So they must inform you that they are going to suspend or withdraw your accreditation. You, as the broker, can then respond back to the council with your reasons why this happened. Maybe it was a mishap or a misunderstanding. You give your side of the story. And then the council, it's not the council must consider this response, your response from the broker. So they give you an opportunity to respond. In addition to the provisions of the Medical Schemes Act, brokers are subject to the provisions of the FACE Act as well. Any person acting as a broker must also be licensed as an FSP or be acting as a representative of a licensed FSP. That we also know. But if you're not a broker and you're a representative and you sell long-term and short-term, and you also want to sell healthcare benefits, you can ask your employer, and if they allow you, they'll send you on training and so on. Then you, as the employer, as an employee, must also be accredited. The reason is so that you know how each different company's medical products works. What are their benefits, advantages, disadvantages comparing to others, etc., etc. You know what you need to sell and how to sell it. Otherwise, you're not going to be able to do it successfully. So when you're looking at assisting clients to make informed decisions, the primary purpose of an intermediary, a broker, is to provide their clients both at employer and individual level with sound financial advice to allow them to select an appropriate medical scheme to meet their medical requirements in as far as it is affordable. Therefore, you must understand the medical scheme benefits, the clinical risk within the scheme, the financial performance and service levels. Your clients would want the reinsurance of long-term sustainability of the medical scheme recommended to them and the benefit structure of the product recommended that will serve their needs optimally. The FACE Act in the General Code of Conduct stipulates that the financial service provider, FSP, must at all times, very important, at all times, render financial services based on the following fit and proper criteria. You must always be honest. You must be fair. You must treat your clients with due skill, care, and diligence. In the interest of the clients, not in the interest for yourself and commission, and with the integrity of the financial services industry. All right, that is what you must do, always, at all times. Section 7 of the FACE Act General Code of Conduct provides that an FSP must provide a reasonable and appropriate general explanation of nature and material in terms of the relevant contract or transaction to a client, and whenever reasonable and appropriate, provide for the client any material contractual information in possession of the provider. The FSP must also provide appropriate information regarding the nature and extent of the benefits to be provided, any exclusions of liability and restrictions, or circumstances in which benefits will not be provided. Section 8, subsection 1A and B of the FACE General Code of Conduct stipulates that an FSP other than a direct marketer must, prior to providing a client with advice, in other words, before you provide the client with advice, take reasonable steps to seek from the client appropriate and available information regarding their financial situation. What can they afford? it's no point in you want to sell them a medical scheme for 3,000 a month, but they can only afford 1,000 a month. Financial product experience, what do they know about the product? So it's the client's financial situation, financial product experience, and any objectives to enable the provider to provide the client with appropriate advice. This means that the broker needs to conduct an analysis for advice based on the information obtained from the client. The recommended analysis steps are outlined further on in this unit. So we'll get there and we'll look at it a bit later. Section 22 of the Consumer Protection Act makes provision that the communication is in everyday languages, so normal languages, not in medical terms, so that any consumer with average literacy skills and minimum experience as a consumer of these financial products or services could be expected to understand the context, significance, and importance of the notice, document, or visual representation. This requirement is also dealt with in the FACE General Code of Conduct, Section 3, subsection 1A1, that states representations made and information provided to a client by the provider must be provided in plain language, avoid uncertainty or confusion, and not be misleading. However, from a business perspective, quickly understood language without technical jargon would assist the advisors, the FSP, with producing clear, effective business communication, from letters to contracts, from reports to websites. These communications are easy for customers to understand and prevent misunderstandings between the advisor, FSP, and the client. Section 9 of the FACE General Code of Conduct stipulates that an FSP must maintain a record of advice that must reflect the basis on which the advice was given. A provider must, subject to and in addition to the duties imposed by Section 18 of the Act and Section 3, subsection 2 of this Code, maintain a record of the advice furnished to a client as contemplated in Section 8, which record must reflect the basis on which the advice was given, and in particular, a summary of the information and material on which the advice was based, the financial products which were considered, and the financial product or products recommended, with an explanation of why the product or products selected are or are likely to satisfy the client, its identified needs and objectives. So it is also provided that such a record of advice is only required to be maintained where, to the provider's knowledge, a transaction or contract in respect of a financial product is concluded by or on behalf of the client as a result of the advice furnished to the client. A written copy of the record of advice must be provided to the client within a specific time. That's the end of this part. If you've got any more questions, you know what to do. Have a lovely day. See you in the next part.